Introduction. This presentation is a personal reflection on a real event based on publicly reported information from reputable media sources. It is presented as one of many examples of a broader problem in the American judicial system: judicial unaccountability and the absence of an effective mechanism to stop judicial lawlessness when it occurs. The purpose is not merely to examine one judge or one courtroom incident, but to consider what this case reveals about judicial power, accountability, and the consequences when those entrusted with enforcing the law are themselves accused of disregarding it. Justice stops where judicial whim begins. On August 13, 2024, 15-year-old Eva Goodman entered Judge Kenneth King's courtroom at Detroit's 36th District Court as part of a youth field trip organized by the Greening of Detroit, a local environmental nonprofit. She was not accused of a crime. She had not been arrested, charged, tried, or convicted. She had no lawyer because she was a visitor, not a defendant. During the visit, she fell asleep while the judge was addressing the group. Judge King ordered Eva to be placed in jail clothing and handcuffs, and threatened her with juvenile detention before her peers. The incident was transmitted through the court's live stream. King later acknowledged that he wanted the experience to look and feel very real, even though there was probably no actual likelihood that he would send her to jail. Most importantly, what law had Eva broken? The contemporaneous reports identify no criminal statute, juvenile offense, or formal contempt charge arising from her conduct. No complaint, citation, delinquency petition, or charging document was reported. No prosecutor presented a case against her, and no lawful adjudication occurred before she was restrained and threatened with confinement. Falling asleep during a courtroom field trip may be inattentive or discourteous, but the available reporting identifies no law making it a crime punishable by handcuffs, jail clothing, or juvenile detention. The Greening of Detroit stated that, had the students been considered disrespectful, the appropriate response would have been simply to ask them to leave. Those questions seem almost beside the point because the judge did not appear to be applying law. He was applying himself. The courtroom became an extension of his personality. His irritation became an offense. His sense of disrespect became evidence. His desire to teach a lesson became procedure. His will became the sentence. That is the precise moment when justice stops and judicial whim begins. Ms. Goodman's reported offense was that she fell asleep while Judge Kenneth King was addressing the visiting students. The judge placed the teenager in jail clothing and handcuffs and threatened with juvenile detention before her peers. The event was transmitted through the courtroom live stream. King later explained that he wanted the experience to look and feel very real to her, although he acknowledged that there was probably no real likelihood that he would place her in jail. That admission exposes the character of the exercise. The machinery of criminal punishment was used not to carry out a lawful judgment, but to manufacture fear and obedience. What statute authorized that performance? No reported criminal statute made falling asleep during a field trip presentation an offense. What charge had been filed? None was identified. What evidence had been presented? Apparently nothing beyond the judge's own observation and his personal interpretation of the girl's attitude. What lawful sentence could be imposed? None had been established through any recognizable criminal or juvenile proceeding. Why were there any consequences at all? The limited consequences imposed on Judge Kenneth King appear to have resulted less from the ordinary accountability mechanisms of the judicial system than from the fact that the incident was publicly visible. The courtroom livestream created an objective record that could not easily be reduced to competing recollections or dismissed as a misunderstanding. Once reputable news organizations circulated the footage and the judge's own explanation, court administrators were forced to respond to conduct that the public could evaluate for itself. Without that recording, the teenager's account would probably have entered the court's internal complaint process as the unsupported accusation of a child against a sitting judge. The matter might then have been reframed as courtroom management, an exercise of contempt authority, or an unfortunate but discretionary effort to maintain respect and order. The complaint could have disappeared into the bureaucratic machinery of judicial review, where disputed conduct is often characterized as a legal or discretionary matter rather than misconduct. The live stream changed the balance of power. The judge controlled the courtroom, but he did not control the public record. Viewers could see that the girl was not a defendant, had not been accused of a crime, and was nevertheless subjected to the symbols and fear of criminal punishment. Public exposure made complete institutional silence difficult. This suggests an uncomfortable conclusion. The system did not restrain the judge when the child needed protection. It reacted only after technology and public reporting made the conduct impossible to conceal or comfortably reinterpret. The consequences were small, but even those consequences may have depended on the existence of evidence outside the judiciary's usual control. Without the live stream and subsequent press coverage, the likely response would have been that the judge acted within broad authority to maintain courtroom order, or, at most, that he made a discretionary mistake not warranting meaningful discipline. Had an ordinary public official intentionally detained a 15-year-old visitor who had committed no identified offense, ordered her into jail clothing, had her handcuffed, threatened her with incarceration, and publicly subjected her to a simulated proceeding, the incident would likely have triggered an immediate criminal investigation, not merely training and reassignment. Investigators could examine false imprisonment, unauthorized restraint, assault or battery, cruel treatment of a child, misconduct in public office, and the willful deprivation of constitutional rights under color of law. Depending on the facts proved, Michigan unlawful imprisonment alone can carry up to 15 years in prison and a $20,000 fine. Ordinary assault and battery can carry up to 93 days in jail. Qualifying child abuse can range from a misdemeanor carrying up to 1 year to serious felonies carrying many years or even life imprisonment. And a willful federal civil rights violation under 18 U.S.C. Section 242 ordinarily carries up to 1 year, increasing to as much as 10 years when bodily injury or specified aggravating circumstances are present. Yet the judge was initially removed for only several weeks, sent to social-emotional training, and transferred to a lesser docket. The contrast exposes the institutional double standard. When an ordinary person uses confinement, restraints, threats, and humiliation without legal authority, the system asks which criminal laws were violated. When a judge uses the same machinery, the system first asks whether the conduct can be renamed poor judgment, courtroom management, or an excessive exercise of discretion. Intentional infliction of emotional distress and false imprisonment may also support substantial civil damages, but they do not themselves carry fixed prison terms because they are ordinarily civil claims. Likewise, unlawful imprisonment under the Michigan felony statute requires specific aggravating elements, so it should not be asserted as conclusively established merely from the reported facts. The response from the system was revealing. King temporarily lost courtroom duties, received social-emotional training, and was reassigned from major felony matters to traffic cases. Later, the Michigan Judicial Tenure Commission pursued formal disciplinary proceedings. Yet he returned to the bench. The public was invited to regard the reassignment as accountability. But imagine another public employee doing the same thing. Imagine a teacher placing a student in handcuffs and prison clothing because she slept during class. Imagine a government administrator ordering a visitor detained because he felt personally insulted. The matter would probably be described not as an error of temperament requiring training, but as an abuse of authority. The robe changes the vocabulary. When ordinary people misuse force, we speak of unlawful restraint, intimidation, humiliation, or civil rights violations. When judges do it, the system begins searching for softer phrases: poor judgment, inappropriate conduct, courtroom management failure, or an educational exercise that went too far. The difference is not merely linguistic. It reflects a deeper institutional belief that a judge's intentions can excuse actions that would be intolerable from anyone else. The incident occurred on August 13, 2024, in full public view. The video record already existed. The judge's identity was known. His own statements explaining his purpose were public. There was no hidden evidence to locate, no complex forensic reconstruction to complete, and no uncertainty about who ordered the handcuffs and jail clothing. Nevertheless, the Michigan Judicial Tenure Commission did not file its formal complaint until November 13, 2025, approximately 15 months later. By August 2026, nearly 2 years after the child was punished instantly, the disciplinary proceedings still had produced no publicly announced final sanction. The contrast reveals the true speed of judicial accountability. A judge could transform a visiting child into a prisoner within minutes. The judicial system required more than a year merely to convert the publicly recorded episode into a formal accusation. The child received immediate restraint, humiliation, and fear. The judge received notice, counsel, pleadings, amendments, a specially appointed master, scheduling orders, and years of procedure, all while apparently continuing to exercise judicial authority. This is not merely delay. It is institutional protection expressed through procedure. The judiciary grants itself every safeguard that the judge denied the child. Notice, representation, time to prepare, an opportunity to answer, neutral review, and protection against premature punishment. Those safeguards are legitimate, but their selective distribution is impossible to ignore. The person accused of judicial misconduct receives meticulous due process. The 15-year-old visitor received handcuffs first and questions never. Without the live stream and national reporting, even the delayed complaint might never have appeared. The episode could have been absorbed into the confidential grievance machinery and described as courtroom management, an exercise of contempt authority, or an error within broad judicial discretion. Public visibility did not produce swift justice. It merely made complete institutional silence more difficult. Defenders of the system point to appeals, disciplinary commissions, reassignment, retraining, elections, and civil lawsuits. Break. 500 ms. These remedies are presented as proof that no judge is above the law. Yet most of them operate only after the injury has become irreversible. The teenager cannot unexperience the handcuffs. But delayed accountability is a weak restraint on immediate power. The deeper question is not whether a judge may eventually be criticized. It is whether the law can stop the judge at the moment the judge chooses to abandon it. Almost always, it cannot. A profession judging itself. The judicial system also suffers from the natural solidarity of a closed profession. Judges review judges. Lawyers prosecute complaints against lawyers. Judicial commissions often include judges and legal professionals who, assumable, will distinguish misconduct from mere legal error. Appellate courts grant deference to trial judges because they occupied the better position to observe the case. Every layer begins with a presumption of institutional legitimacy. This is how law becomes asymmetric. The citizen is bound by the rule. The judge is guided by it. The citizen's violation produces punishment. The judge's violation produces interpretation. Justice stops where judicial whim begins. When a judge commits crime, the crime changes its name. Had an ordinary person ordered a 15-year-old girl into custody, forced her into jail clothing, placed her in handcuffs, publicly humiliated her, and threatened her with juvenile detention merely because she fell asleep, the conduct would not be politely described as a lapse in judgment. Police and prosecutors would at least examine possible allegations such as false arrest or false imprisonment, unlawful restraint, assault or battery arising from unauthorized physical restraint, intentional infliction of emotional distress, child abuse or cruel treatment of a child, deprivation of constitutional rights under color of law, abuse of official authority, conspiracy or aiding and abetting by anyone who knowingly helped carry out the detention. That does not mean every offense could necessarily be proved against Judge Kenneth King. Criminal statutes have specific elements, defenses, jurisdictional limits, and demanding intent requirements. But the contrast remains unavoidable. Conduct that would ordinarily trigger an investigation for serious wrongdoing was initially answered with 6 weeks away from the courtroom, social-emotional training, and reassignment to traffic cases. The Michigan Judicial Tenure Commission did not authorize a formal misconduct complaint until later. False imprisonment and unlawful restraint. At the most basic level, the teenager was allegedly not free to leave. She was taken into custody, changed into jail clothing, handcuffed, detained, and threatened with incarceration. Even though she was neither a defendant nor the subject of an actual criminal proceeding. The formal complaint reportedly quotes King directing that she be treated like a regular defendant held in contempt. Michigan's statutory crime of unlawful imprisonment requires more than every unauthorized restraint. It applies when a person knowingly restrains another under one of several specified aggravating circumstances. Therefore, one should not declare that this statute was necessarily violated without applying every element. But ordinary civil false imprisonment is broader in concept. Intentional confinement without lawful authority. A private citizen who orchestrated this episode could hardly expect the public to accept. I was only trying to teach her a lesson. That explanation would more likely support the conclusion that the detention was deliberate. Deprivation of constitutional rights under color of law. The most serious potential federal concept is Title 18 of the United States Code, Section 242. It makes it a crime for someone acting under color of law to willfully deprive a person of rights protected by the Constitution or federal law. A judge using court officers, restraints, detention facilities, and apparent contempt authority is acting under the color of governmental power, even when the power is allegedly misused. Possible constitutional interests could include the right not to be deprived of liberty without due process of law and the right to be free from unreasonable seizure. But a criminal prosecution under Section 242 would require proof of willfulness. not merely bad judgment, negligence, or an erroneous interpretation of authority. That is a demanding standard, and only prosecutors could determine whether the available evidence satisfied it. Still, the statute demonstrates the seriousness of the underlying principle. Government officials do not receive a legal privilege to detain people simply because official power makes detention possible. Child abuse or cruel treatment. Michigan's child abuse statute reaches intentionally caused serious physical or mental harm and, at certain levels, acts likely to cause serious harm or acts legally considered cruel toward a child. Again, whether this particular episode satisfies a specific degree of child abuse would depend on statutory definitions, evidence of harm, intent, and prosecutorial judgment. Public humiliation alone does not automatically establish criminal child abuse. But consider the factual setting. A homeless or housing-insecure teenager reportedly fell asleep during a field trip. Instead of asking whether she was exhausted, ill, frightened, or experiencing hardship, an adult authority figure allegedly converted her vulnerability into a public spectacle. She was dressed as a prisoner, restrained before classmates, threatened with confinement, and displayed on a live stream. The family later alleged fear and severe emotional distress. Had a teacher, youth program director, security guard, or private adult done this, the word abuse would arise immediately. Because a judge ordered it, the system initially called it training-worthy misconduct. Assault, battery, and intentional emotional harm. Handcuffing is physical contact and restraint. When lawfully performed by an authorized officer, it may be privileged. Without lawful justification, similar conduct can support civil claims involving battery, assault, false arrest, or false imprisonment. The alleged mock proceeding and threat of juvenile detention could also support a claim for intentional infliction of emotional distress if the conduct were found extreme and outrageous and caused legally sufficient harm. The family's civil lawsuit reportedly alleges civil rights violations, humiliation, fear, and severe emotional distress. Yet, even civil accountability encounters the judicial immunity barrier. King has invoked judicial immunity, and the litigation reportedly remains contested. The key question is whether these were genuine judicial acts within arguable jurisdiction or extrajudicial acts performed in the courtroom under the appearance of authority. That is the heart of the institutional privilege. The more closely an abuse resembles an exercise of judicial power, the more likely judicial immunity may protect the person who committed it. Everyone who participated. The judge apparently did not personally perform every act. Court personnel carried out his orders. Hat raises another disturbing question. Why did no trained adult say, "Judge, this child is not a defendant, and we have no lawful basis to restrain her"? Judicial power becomes especially dangerous when everyone around the judge treats obedience as more important than legality. The officer applies the handcuffs. Staff provide the jail clothing. The live stream continues. No one stops the unlawful behavior because the order came from the bench. An unlawful command should not become lawful merely because it is spoken by a judge. Yet institutional hierarchy can transform resistance to a questionable order into a career risk, while compliance is treated as normal professionalism. Less than a slap on the wrist. The initial consequence was extraordinarily mild compared with the experience imposed on the child. She experienced immediate detention and humiliation. He received temporary removal and training. She wore handcuffs. He changed dockets. She was threatened with juvenile custody. He returned to judicial work. The later misconduct proceeding matters, and its ultimate result should not be prejudged. But delayed professional discipline does not erase the asymmetry. The system effectively communicated. When a child appears disrespectful, restraints may be used immediately. When a judge allegedly abuses restraints, accountability may be studied gradually. That is not equal justice. It is institutional caste. 2. The broader judicial rule. For ordinary citizens, the law asks, did you have authority? For judges, the system asks, could you have believed you had authority? For ordinary citizens, did you restrain another person? For judges, was the restraint sufficiently connected to a judicial function to trigger immunity? For ordinary citizens, did your conduct traumatize a child? For judges, would training, reassignment, or a confidential disciplinary process be more appropriate than punishment? Thus, the same conduct is translated into two legal languages. Outside the courthouse, it may be described as detention, coercion, abuse, or deprivation of rights. Inside the courthouse, it becomes discretion, contempt management, poor temperament, or an unfortunate educational exercise. That is why the episode belongs in the larger reflection. Justice stops where judicial whim begins, and judicial whim prevails because the system repeatedly renames the judge's violation before deciding whether to excuse it. The robe does not merely confer authority. Too often, it changes the vocabulary applied to wrongdoing. What would be an offense in the hands of a citizen becomes an error in the hands of a judge. What would justify immediate restraint of an ordinary offender produces retraining for the judicial one. The child was treated as though she had no rights because a judge wanted to make a point. The judge was treated as though he had made a mistake because the system wanted to protect its own legitimacy. That is not a slap on the wrist. It is barely the movement of a finger. When an ordinary person uses confinement and humiliation without authority, the system searches the criminal code. When a judge uses the same machinery, the system first searches for a disciplinary explanation.